Please, Lordship, I beg to mention item 13, my lord. Yeah, my lord, it's a criminal appeal.
On premier by the appellant, this is matter to 3 weeks.
Only one. I had one small prayer, my lord, that after going through the paper book, my lord, it appears that the 161 of the victim was not enclosed, so I may be allowed to file it by way of an additional paper book, my lord. The 161 of the...
In that case, then you have to wait for the matter to be called up.
Or in the meanwhile, we can file it because it's part of the record only, my lord. I'll not file it by way of affidavit or anything. Just put it in the... Can we adjourn, then in the meanwhile we'll...
Okay, so
Oh, much obliged.
Please, Your Lordship, I beg to mention item number 7, Your Lordship. Your Lordship, in this matter, I have received the affidavit in opposition filed by the respondent number 1. But Your Lordship, I'm seeking 3 weeks' time, Your Lordship, since my senior is out of station. Your Lordship, can the matter be fixed specifically on a Friday?
it cannot be at your own choosing. We have to look at the convenience of the court also.
May please, my lord, here I have filed an affidavit pertaining to CRP number 21/2016, filed by the Meghalaya State Sports Council. So, with regards to CRP number 28, we'll be filing if necessary or not on the next date.
Let us be clear. You're submitting in case number 28.
CRP 28.
21.
No, 28.
So 28.
21.
No, he's filed in 21.
Just a moment. Let us see. Let's not be confused. One at a time. So in 28, you have received the affidavit filed by.
The respondent number 1.
Okay. Who's the respondent number 1?
My lord, I'm for
You are. So you have filed an affidavit,
My lord.
and the state has received the same. So no rejoinder required. What is the affidavit about?
My lord, here we have
What is the affidavit about?
we have stated the issues raising the materiality as well as the parawise challenging. Since your lordships has in the last occasion has directed us to file an affidavit or a petition, so we have filed by way of an affidavit, bring all those in record.
Fine. So that's 28. And madam, you said you'll file a response to it.
Your Lordship, I will seek instructions, Your Lordship, regarding the same.
Required. Is it required? What about 21?
It's in 21, my lord, we have filed.
21 or 28?
21.
21.
21. Meghalaya State Sports Council.
You made me receive, but they made me receive it.
21, I'm for the petitioner, my lord.
21, my lord, sorry.
You
I
have
have filed CRP in 21.
And what about 28? You have what have you received in 28?
I'll supply copies to the senior counsel.
Supplies copies supplied to all the parties, my lord.
So all the
Yeah, because common.
yes.
You're a common respondent.
common response.
Simply adjourn, my lord. Without it. Because that is also already understood, because Supreme Court direction is there to hear the maintainability.
On premier by petitioner. This is matter after 1 week.
3 weeks, Your Lordship.
Why 3 weeks?
2 weeks will do.
It's not in station, that's why.
3 weeks. It's 2016 matter.
Your Lordship.
Obliged.
Obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 9, Your Lordship. Item number 9, Your Lordship.
You're for?
For respondent, Your Lordship.
For petitioner, my lord.
Any objection?
No objection, my lord.
On premier by the respondent, not objected to by petitioner. list this matter up to 3 weeks.
My lord, I'm making a prayer for item number 10 also, my lord. I'm praying for the 3 weeks time, my lord.
You are for?
For petitioner. For the appellant, my lord.
And who's for the?
I'm for the respondent.
Any objection? On pre-meet by the appellant, not objected to by respondent. This is matter of 3 weeks.
Item number 8. Come after 3 weeks, Your Lordship.
Matter has been heard, not heard.
No.
On pre-meet by the respondent Union of India, not objected to by petitioner. This is matter of 3 weeks.
Yeah, please, Lordship. Back to mention item number 14, Lordship. It comes after a week, Lordship.
No objection, Your Lordship.
Your Lordship, I'm appearing for respondents 3 and 4 on this matter, Your Lordship.
I'm for 1 and 2, Your Lordship.
Yes, sir. I filed my power also, Your Lordship, on the last occasion.
Okay. On pre-meet by the petitioner, not objected to by respondents. This is matter up to 3 weeks.
Obliged, Your Lordship.
Lordship, item 11 and 12, Your Lordship. 11 and 12, Your Lordship.
On 11, I'm appearing. I have no objection. 12 is.
On pre-meet by the appellant, this is matter to 3 weeks. तो कोई भी pre-meet by the petitioner, this is matter of 2 weeks.
Yeah, please, Your Lordship. I beg to mention item number 15, Lordship.
15.
Yes, Lordship. The counsel for the respondent number 2 is currently out of station, Lordship. Therefore, I pray for 2 weeks' time, Lordship.
I don't have any objection.
On pre-meet by the respondent number 2, not objected to by petitioner. This is matter of 2 weeks.
Highly obliged, Lordship.
Supplementary cost list, item number 1. Please, Your Lordship.
This is a
With Your Honour's with Your Lordship's permission, I would like to make a small submission, Your Lordship. Your Lordship, this matter was initially listed in Honourable Justice Thankyu's court. However, he recused himself from the matter and it was scheduled to be listed here on the 23rd, Your Honour. Your Lordship, the senior conducting counsel had appeared before Your Lordship on the 23rd itself, stating that he will be out of station for this week. And he had requested this Honourable Court to fix the matter on the 7th of July. So, Your Lordship, since the matter is fixed today, I'm here for Your Lordship with a prayer that the matter may be listed on the 7th of July, Your Lordship.
I'm opposing that prayer, Lordship, because there's some urgency in the matter. The trial court proceedings are listed on the 3rd of July, and my friend appears on caveat. I believe that the caveator will become necessary if I make out a case. So, if Lordship will permit me, I'll.
Yes.
Because I'm seeking to stay on those.
So, if there's a caveat, it stands to reason that the caveator would be present in court.
Surely, Lordship, but the caveator should not seek
for the caveat to be discharged. Number 2, since a prayer has been made specifically by the said caveator, so on grounds of personal difficulty, what do we do, Mr. Sahai?
Lordship, because the suit will proceed on the 3rd of July, and then I'll be in a there'll be some handicap because here there are interim orders being pressed by the caveat. Let them make a statement that on the 3rd they will not press press their interim relief. I have no difficulty. Let them make a statement on the 3rd. Nothing will be done in the suit.
Your Lordship, anyway, on the 3rd, the matter is fixed for filing of our show cause on their application under Order 711. So we will be only filing our show cause on that day.
Subject to that undertaking, Lordship, I have nothing to say, because if they don't press for any interim relief in the suit, they can surely be accommodated to the 7th.
If the statement is made at the bar that they're not pressing it, they're just filing the show cause, then we have no objection.
Who's filing show?
It is fixed for...
I'm appearing for the defendant before the trial court.
Your Lordship, it is fixed for the plaintiff.
You are the plaintiff?
Yes, Your Lordship. We will be filing our show cause on the 3rd under section Order 11, 711. So that'll be all for on the 3rd, Your Lordship.
Lordship, we'll take that as a statement.
What, Mr. S.I.? Leonard, you're GA, Mr. Sahi?
Yes, Lordship. I'm representing the government in this one.
Does it befits you?
Lordship,
Sorry, Leonard GA appearing for the state petitioner. However, before the Leonard Council could apprise this court of the matter in hand, Miss ACM, Leonard Council for the
Respondent number 1.
Respondent number 1 has interjected and made a submission that the respondent number 1, who has since filed a caveat before this court, would prefer that the matter be heard in presence of the learned conducting counsel of the said respondent, who is personally indisposed today. Prayer has been made that this matter may be adjourned for a week. In response, Mr. Sahai had submitted that there is urgency in the matter, inasmuch as the matter pertaining to the same subject matter as is present in this court, in these proceedings before this court, is proceeding before the trial court, and if any adverse order is passed in the case before the trial court, the same would have a bearing on the proceedings herein, and as such, though not exactly opposing the prayer made for adjournment, the learned GA has submitted that the parties, particularly the respondent number 1, who is also the plaintiff in the case before the trial court, give an undertaking that he will not press for any interim order before the said trial court when the matter comes up on 3rd July. In all fairness, the learned counsel has submitted, for the respondent number 1, has submitted that the case before the matter before the trial court fixed on 3rd July is only for filing of a show cause against a petition filed by the petitioner, state petitioner, defendant, against an application under order 7. What application have you filed, Mr. Sai?
7 Rule 11.
Order 7 Rule 11.
Order 7 Rule 11, CPC. Be that as it may, since the parties have given an undertaking before this court that the interim prayer would not be pressed for before the trial court, the adjournment sought for is allowed. Accordingly, this is matter after 1 week.
I'm so grateful.
Item number 2.
My lord, this is a similar bail application, my lord, which was filed earlier, my lord. Accused in the same FIR, my lord. That matter is coming on 3rd of July, my lord. And then interim bail was granted. The order is, my lord.
Yes.
The FIR is at page 16A, my lord.
Can I get a copy, please?
Of
the order.
It is covered in nothing.
Same matter. FIR is page 16A, my lord. The accused number 1 moved earlier, my lord, and this is accused number 2 in this.
Case number 2.
It come together on the same day, 3rd of July, my lord.
Heard Dr. N. Musika, Learned Senior Counsel, appearing for the petitioner. Also heard Mr. H. Karwalang, Learned Additional Senior GA, appearing for the state respondent. The Learned Senior Counsel has submitted that this application for grant of pre-arrest bail has been filed on the basis of an apprehension faced by the petitioner herein, apprehension of arrest, in connection with Nongpo PS case number 44 and bracket 4 of 2023. It is however submitted that this court in a similar case involving the same subject matter, that is the FIR in question, and also in the same Nongpo PS case number 44/4 of 2023, on prayer made, the petitioner therein was allowed to go on interim bail, and the matter was fixed for further hearing on 3rd July. Similar prayer is also made as far as this instant petition is concerned, to the extent that the matter may be taken up on 3rd July, and in the meantime, the prayer for grant of interim bail may be allowed. Next, Mr. H. Karwalang, being seized of the situation, has not made any objection as far as the prayer made by the petitioner is concerned. Accordingly, was the CD directed to be called for?
Lordship, the CD may be for instructions, my lord, whether section 41A notice was issued or not.
Okay.
Lordship, call for the CD.
Lordship, call for CD also.
Being seized of the situation. on consideration of the submission made, the prayer of the petitioner as far as grant of interim bail is concerned is allowed. However, while listing this matter on 3rd July 2023, apart from the status report to be filed as regard the proceedings of PS case number 44/4 of 2023 is concerned, the prosecution is also directed to file copy of the CD on the said date.
If may please, Your Lordship. Lordship, if the same observations are made in the previous order, Lordship, that the petitioner shall not tamper or abscond with the evidences.
I heard ka line mga tho. It is
Till the next.
needless to say, the petitioner, while on interim bail, shall not abscond or tamper with the evidence. What else do you want?
Much obliged, Lordship.
Item number 3.
My lord, to address the issue that cropped up yesterday, my lord, I am submitting a small compilation.
We're talking about the supplementary charge sheet.
Supplementary charge sheet. My lord, page 12 is that case. Not page 12, my lord. Page 13, sorry. My lord, page 13. In this case, my lord, what the Supreme Court had decided was, my lord, the relevant portion is at page 24, my lord, of the compilation. I will read paragraph 34. In the instant case, it is clear from the facts that during the pendency of the investigation, supplementary charge sheets were filed by the investigating agency just before the expiry of 60 days with the purpose of scuttling the right to default bail accrued in favor of the accused. The factual position was missed by the trial court, and instead of offering default bail to the accused, the trial court mechanically accepted the incomplete charge sheets filed by the investigating agency and further continued the remand of the accused beyond the maximum period specified. The investigating agency and the trial court thus failed to observe the mandate of law and acted in a manner which was manifestly arbitrary and violative of the fundamental rights guaranteed to the accused. Well, subsequent to this, my lord, the Enforcement Directorate made a mention for recalling of this particular order. Now, that also, my lord, I have enclosed. Here, my lord, page 12. A very short order was passed by the Supreme Court, page 12 of the compilation.
Yes.
This is upon being mentioned, taken on board, list the proceedings on 4th May 2023 before a bench of 3 judges. In the meantime, in the event that any other applications have been filed before any other court, on the basis of the judgment of which recall is sought, they shall be presently deferred beyond 4th May 2023. Subsequent to this, my lord, another order was passed in the same case. That lordship will find at page 11. Page 11, my lord. The order reads, in continuation of the interim order of this court dated 1st May 2023, we clarify that the order shall not preclude any trial court or as the case may be High Court from considering an application for grant of default bail under section 167 of the Code of Criminal Procedure 1973, independent of and without relying on the judgment dated 26 April 2023 in writ petition number such and such. Thereafter, my lord, the Supreme Court itself, lordship will come to page 1 now. My lord, Supreme Court in a very similar case, like my case, my lord, has granted bail. In spite of that order, there was no stay of that order, my lord. A recall was sought, but no stay was granted. The only thing the Supreme Court clarified is that there is no embargo on any High Court or the trial court in granting bail under 167. And that issue is to be decided on a later date. Now, my lord, page 1. Upon hearing the counsel, the court made the following order. Heard the learned counsel for the petitioner and also the learned ESG for the respondent and perused the petition papers. The primary question sought to be urged in the instant petition is with regard to the petitioner having acquired a right to seek statutory bail since the charge sheet file is without the FSL report. The aspect of the matter at this juncture need not be gone into, since the said issue is pending consideration in a batch of petitions which would take some time for hearing, and this petition is also to be considered along with those petitions. For the present, we note that even in other pending cases before this court in SLP number such and such and other similar petitions, without reference to the statutory bail, taking note the petitioners have been in custody for some time and the trial would take some more time to conclude, we direct grant of bail to the petitioners. In that view, in the instant case also, we direct that the petitioner be released on bail subject to petitioner diligently participating in the trial. All contentions are however left open to be considered with regard to the issue relating to default bail. List the instant petition along with the other connected petitions in the usual course. Now, all these were taken into consideration, and my lord.
The consideration of bail here is on a different premise.
My lord, very similar to my case also. My lord, this is also a case where after that...
Not necessarily on the aspect of...
No, my lord. That is yet to be decided. But there is no stay of that matter. Subsequent to this, my lord, this honorable court also passed a very similar order. Now, my lord, interestingly, I have gone through this order. My lord, my case is so similar to this particular case. Here also, my lord, I was arrested on the basis of, my lord, I am not in conscious possession. Here also, my lord, interestingly, the person also suffers from HIV. So, my lord, I am pressing bail on 3 grounds, like I have urged yesterday, my lord. There is no embargo, my lord. Supreme Court has not said that bail cannot be considered if the charge sheet is incomplete. It is only referred the matter to a three-bench judge to decide the matter, my lord, later stage.
Yes, sir. Finished. May it please your lordship. Lordship, the order which is at page 1, which my friend has quoted, your lordship, that is the order dated 1/5/2023, your lordship. Lordship, kindly come to page 1 of that additional affidavit. This is the order of 1/5/2023.
Yes.
Then subsequently, your lordship, in that, lordship, kindly come to page 9. Lordship, the relevant page at page 11.
Yes.
It says like this, your lordship. In continuation of the interim order of this court dated so and so, we clarify that the order shall not preclude any trial court, or as the case may be, High Court from considering an application for the grant of default bail under section 167 of the Code of Criminal Procedure 1970, independent of and without relying on the judgment dated so and so repetition. That is the judgment of Shabaria.
Page 13, I read closer. Page 13.
Ritu Shabaria, your lordship. Page
13.
Lordship, kindly come to page 13.
Yes.
This is the judgment, your lordship, where the Honorable Sumko has said that filing of the charge sheet without the copy of the FSL, that it is an incomplete charge sheet, and in that view of the matter, the accused is entitled to be released on bail, your lordship. Then coming to this, lordship, I'll refer to some other authority, your lordship, from various high court, your lordship, regarding on this issue, your lordship. First, I'll come to this petition, your lordship. I petition. Lordship, my first contention in this bill application is that it is the admitted fact, your lordship, that the accused was arrested on 16/3/2023 and the charge sheet was filed on 9/5/2023. In my humble and respectful submission, your lordship, it is within the statutory period of 60 days as contemplated under section 167 of the CRPC, your lordship.
Yes, I think there is no quarrel there.
Lordship. Another aspect, your lordship, the bail application which was filed before the learned trial court there, it is not a case, it is not a bail of a default bail application. There is no default bail application, your lordship. It is a regular bail. Lordship, kindly come to the order. That, your lordship, will find it at page 46. It is not a default bail application. It is not a bail filed under section 167 of the CRPC, your lordship. Rather, it is a bail application, regular bail under section 439 of the CRPC. Lordship will find it at page 46.
Yes.
Lordship, the sentence reads, seen bail application 439 CRPC. Read with section 37 of the NDPS Act. So, lordship, it is the admitted fact, your lordship, that this is not a default bail application filed before the learned trial court. Rather, it is a regular bail application under Section 49. So, in that view of the matter, Your Lordship, the accused, in my humble and respectful submission, Your Lordship, cannot take advantage of that, Your Lordship. Lordship, in fact, different High Court, Your Lordship. First, I'll come to the that just because when the charge sheet is filed within a statutory period, Your Lordship, and a mere fact that a chemical report, a chemical analysis report, or the FSL report has not been annexed with the charge sheet, that is not a ground for grant of bail, Your Lordship. To that, Your Lordship, I'll file. Lordship, I'll refer to the judgment of the Honorable Sikkim High Court, Your Lordship. If Lordship will kindly come to page para 17. Para 17, Your Lordship, page is not there, Your Lordship. Para 17. May I read it, Your Lordship?
This one. Para 17.
Para 17, Your Lordship. May I read it, Your Lordship?
Please.
In the instant case, the petitioner is in judicial custody since 8/6/2022. In this, indubitably, the charge sheet was filed within the statutory period of 60 days as provided in Section 167 of the CRPC. The SADA not having prescribed the specific period of completion of it. The petitioner alleged that the charge sheet is incomplete on account of non-filing of a forensic report, Your Lordship. The Honorable Supreme Court is yet to determine the question reflected supra in Mahmoud Abbas supra and is therefore seized of the matter. Appositely, I desist from delving into a detailed discussion and opinion on the question pending consideration, and that the provision of Section 167 to Section 173 and Section 190 of the CRPC entails suffice it at this juncture to notice that in Sanjay Dutt versus State through CBI Bombay, the Honorable Court held that the infeasible right to bail under Section 167 of the CRPC ensured to the accused and is enforceable only prior to filing of the charge sheet. That is, it does not survive or remain enforceable on the challan being filed, if already not a bail of. Once the challan has been filed, the question of grant of bail has to be considered and decided only with reference to the merit of the case under the provision relating to the grant of bail to an accused. On the basis of the above, the charge sheet having been filed in the instant case within the statutory period, regardless of the admitted fact of absence of FSL report on due consideration of the fact and circumstances, please, I find no reason to interfere with the finding and conclusion of the learned trial court. So the Honorable Supreme Court, Honorable Sikkim High Court, Your Lordship, say that no, just because a charge sheet has been filed and the report of the FSL is not there, you cannot get a bail under 167. Then, Your Lordship, another judgment, Your Lordship. Lordship, I'll to the judgment of the Karnataka High Court, Your Lordship. Lordship will kindly come to para 8 of the judgment.
This is not reported.
Lordship, at internal page 14.
This is not reported.
Lordship, no, this is not reported, but we just got it. This is from the website of the Karnataka High Court, Your Lordship. Lordship will kindly come to page 14.
Page?
Internal page 14, Your Lordship, para 8 of that judgment. This judgment, Your Lordship, has been referred to the division bench of the Honorable Bombay High Court, Your Lordship. May I read it, Your Lordship? Para 8.
Please.
The admitted fact is that FSL report was not yet in place when the police filed the charge sheet on so and so. The issue whether the petitioner would get a right to get himself enlarged on bail in the absence of FSL report in the charge sheet did not detain this court for for long as the division bench of the Bombay High Court in the case so-and-so was answering a reference to the division bench in view of conflicting view of two learned single judges on the very issue of an accused becoming entitled to enlargement on default bail on the ground that FSL report did not accompany the final report. The division bench answering the question hold us. The main issue which fall for determination in the reference is to whether in a case under the NDPS Act, the investigation can be said to be complete within the period prescribed under section so-and-so when a police report under section 1732 is filed before the special court without any FSL report along. If based upon such a police report an investigation is held as incomplete, then the accused will be entitled to default bail. However, if the investigation is held as complete, no question of default bail would arise. This reference arose on the account of the following, Your Lordship. I'll skip that, Your Lordship. Then I'll come, Your Lordship, to page 19, Your Lordship. Page 19. Therefore, para 42, Your Lordship. I'll read it, Your Lordship.
Yes.
Therefore, on the analysis of the statutory provision as also the decision that have analyzed various sheet of such statutory provision, we believe that a police report for a charge sheet containing the details, so if filed within the period prescribed under section 1, is not vitiated or incomplete simply because the same was not accompanied by a FSL report, and based on there is no question of the accused insisting on default bail. Then Lordship kindly turn to page 31 of the same judgment.
Yes.
Lordship, para I'll come above your Lordship. Manas, so that is this judgment, the judgment of the division bench of the Honorable Bombay High Court, your Lordship.
Yes.
It says supra consider entire spectrum of law and hold that merely because FSL report is not found in charge sheet, particularly if contraband substance is ganja, would not vitiate the charge sheet, for it's become contrary to section 17 of the CRPC and consequent thereof given to question of procedure. The law laid down by the division bench of the Bombay High Court is opposite as the apex court in the case and so or no, does not consider the fact whether filing of the charge sheet would vitiate the proceeding. In the light of it is the considered view of this court that the patient does not get a right to demand so and so that bill is rejected. Then Lordship, another judgment, your Lordship, is Lordship, another judgment from the from Bombay High Court, your Lordship. This is Nabin Kumar Pandu Jaton versus State of Maharashtra, your Lordship. In that judgment, your Lordship, kindly come to page 23, your Lordship. Lordship, in this judgment,
yes,
the
para.
Lordship, this is I'll come to Lordship. Lordship, this is at page 23, your Lordship. In this, just what I would, this will come in para.
So the same reference is made to the case of Manas Krishna.
Para 33, your Lordship. In this judgment, your Lordship, the Honorable Bombay High Court, after referring to the various authorities, your Lordship, then Lordship kindly turn to page 23. Internal page 23, your Lordship. Down below the page 23 is there, your Lordship.
Yes.
Lordship, it reads like this. Question number 1 is answered by holding that even in an NDPS case, a police report containing the detailed Lordship, this is page 20, internal page 23 of that judgment. Yes. Lordship, that is on top, your Lordship. Okay. Question number 1, Lordship, is
yes,
is answered by holding
yes,
that even in independent case, a police report containing the detail prescribed under section 173.2 CRPC is a complete police report and a charge sheet or challan, even if it unaccompanied by CA, mean chemical analyzer, Your Lordship, FSL report, if such a police is filed within the period stipulated under section so, the accused cannot insist upon a different default bail. Then another judgment, Your Lordship, is from Delhi High Court, Your Lordship. This is also on the same question of law, Your Lordship. Lordship, kindly come to para 10 of that judgment. Lordship will find it at page.
Just one.
I'm done page. There is no paging, Your Lordship. Page 11, Your Lordship. Internal page 11, para 10, Your Lordship.
Para?
10. Para 10, Your Lordship. 10 to 14, Your Lordship. Page paragraph 10 to 14, internal page 11, Your Lordship.
To 14.
Lordship, till 14, Your Lordship. Yes. May I read it, Your Lordship? Para 10.
Please.
In the present case, the charge sheet was filed on June 3, 2021. However, without FSL report, the charge sheet was thus filed within the limitation period prescribed under law. The question in dispute narrowed down to as to whether the FSL report formed part of the charge sheet, and it is an essential requisite to file with the charge sheet. FSL report not part of the charge sheet. In so and so, a division bench of this court, that means the Delhi High Court, Your Lordship, observed that a police report does not need to enclose an expert opinion of the government scientific expert with the charge sheet, and thus no bail was granted under section so and so, as the charge sheet was already filed within stipulated time. The observation read as follows. The question raised by the petitioner in a nutshell is whether the investigation of a case under the NDPS Act can be said to be complete in the absence of the report of the scientific officer and chemical examiner. The question is that where the accused person is only found in possession of transporting a prohibited drug or substance, merely two facts have to be established by the prosecution: that the recovery of the quantity or substance, and that the possession of the said recovered material is illegal under the provision of the NDPS Act. Lordship, I would like to emphasize on this, Your Lordship, because I'll come to the case thereafter. It is submitted that the investigating officer would be unable to keep his opinion regarding the second aspect till he obtained the report of the expert, and therefore the report submitted by the investigating officer, even if
you are reading?
Lordship, I'm reading at para 11, Your Lordship, that observation made by the division bench of the Honorable Delhi High Court in Kishan Lal versus State. Lordship is also at page 11, para 11, Your Lordship.
Yes.
Lordship is with me?
Yes.
Lordship, kindly turn to the next page. The content is done.
Yes.
The contention is, Lordship, yes. This is also same, Your Lordship. Then the Honorable Delhi High Court has come to a finding, said no.
Yes.
Then last, Your Lordship, I would like to, Lordship, this is the judgment from the Honorable High Court of Jammu and Kashmir and Ladakh, Your Lordship, at Srinagar. Lordship will kindly come to para 11 of that judgment. The Honorable High Court of Jammu and Kashmir, Your Lordship, has differed with the judgment passed by the Punjab and Haryana High Court, Your Lordship. And in para 12, Your Lordship, of this judgment, Your Lordship, the Honorable Jammu and Kashmir High Court is in agreement with the judgment rendered by the Karnataka High Court, Your Lordship, which I have already read, Your Lordship. Lordship will kindly come up internal page 9 at para 12 of that judgment.
Yes.
My aforesaid view is supported by a recent judgment of the Karnataka High Court. So, Lordship, I need not take Your Lordship time. Lordship, this also bill has been rejected. Then, Lordship, coming in this case, Your Lordship, the fact remains that a content has been made that the recovery was not made, Your Lordship. In this respect, Your Lordship, I would like to It does not matter, Your Lordship, whether recovery was made or not, Your Lordship, provided you have a conscious possession, Your Lordship.
Yes.
Lordship, that is the 2021 Volume 10 SCC, page 100, Your Lordship. If Lordship will kindly come to para 22 of the judgment.
Yes.
The standard prescribed for the grant of bail is a reasonable ground to believe that the person is not guilty of the offence. Interpreting the standard of reasonable ground to believe, a two-judge bench of this court in Chief Shankar Kesari held that the expression used in section 37(1) is reasonable ground. The expression means something more than prima facie ground. It connotes substantial probable cause for believing that the accused is not guilty of the offence charged, and this reasonable belief contemplated in turn point to the existence of such facts and circumstances as are sufficient in themselves to justify recording of satisfaction that the accused is not guilty of the offence charged. The word reasonable has in law the primacy meaning of reasonable in regard to those circumstances of which the actor called on to act reasonably, knows or ought to know. It is difficult to give an exact definition of the word reasonable. Shroud Judicial Dictionary, Lordship, then Lordship kindly come to para 25, or to the bottom, Your Lordship.
Yes.
We shall deal with each of these circumstances. The respondent has been accused of an offence under section 8, which is punishable under section so-and-so, section 8, so-and-so, so-and-so. The concept of possession, Lordship, the concept of possession recorded in section 20 to 21, which provide for punishment for under the act in Madan Lal versus State, this could held us under. Whether there was conscious possession has to be determined with reference to the factual backdrop. The facts which can be called out from the evidence on record are all that the accused person were traveling in a vehicle as noted by the trial court, they were known to each other, and it has not been explained or shown as to how they traveled together from the same destination in a vehicle which was not a public place. Section 20b make possession of contraband article an offence. Section 20 appears in chapter 4 of the Act, which relate to offences for possession of such article. It is submitted that in order to make the possession illicit, there must be conscious possession. It is highlighted that unless the possession was coupled with the requisite mental element, conscious possession, and not mere custody without awareness of the nature of such, Section 20 is not attracted. The expression possession is a polymorphous term which assumes different colors in different contexts. It may vary different meaning in contextually different background. It is impossible, as observed in so and so, to work out as a completely logical and precise definition of the possession uniform applicable to all situations in the context of all statute. The word conscious means awareness about a particular fact. It is a state of mind which is deliberate or intent. Once possession is established, the person who claimed that it was not a conscious possession has to establish, because how he came in possession is within his special knowledge. Section 35 of the Act gives a statutory recognition of this possession because of the presumption available in law. Similar is the possession in terms of Section 54, where a presumption is available to be drawn from possession of illicit article. What amount to conscious possession was also considered in so-and-so, where it was held that the knowledge of the possession of contraband has to be clean from the fact and circumstances of the case. The standard of conscious possession would be different in case of a public transport vehicle with several persons as opposed to a private vehicle with a few persons known to one another. In Malan so-and-so, this court was also observed that the term possession could mean physical possession with animus custody over the property, with animus exercise of dominion and control as a result of concealment or personal knowledge as the assistant of the control and the intention based on the. We refer to the above to reiterate the governing principle. At this stage, the proceeding, it needs only to be clarified that the trial is to take place this court where evidence will be adduced. As regard the finding of the High Court regarding absence of recovery of the contraband from the possession of the respondent, we note that in Union of India versus Ratan Malik, a two-judge bench of this court cancelled the bail of an accused and reversed the finding of the High Court, which had held that As the contraband was recovered from a specially made cavity above the cabin of truck, no contraband was found in the possession of the accused. The court observed that merely making a finding on the possession of a contraband did not fulfill the permit of the section and therefore non-application of mine by High Court. In line with the decision of this court in so and so, we are of the view that finding of the absence of possession of the contraband on the person of the respondent by the court in impugn order does not absolve it of the level of scrutiny required under section 37 so and so of the Act. So, Lordship, just because the contraband or the heroin or the ganja was not discovered from, was not seized from the possession, Lordship, that will not absolve the accused. Lordship, then last, Lordship, kindly come to the last speech, Lordship, at para 34.2, Lordship, which, in my humble respect, is akin to this case, Lordship, in the present proceeding. The complaint note that the CDR analysis of the mobile number used by the respondent indicate that the respondent was in regular touch with other accused person who were known to him. Exactly similar in this case, Your Lordship. Because, Your Lordship, in this case, the accused, Your Lordship, she stayed in Madan Riting, Your Lordship, and instructed her friend to bring the heroin, Your Lordship, and that heroin was bought from Myanmar, Your Lordship. Lordship, Mizoram, Your Lordship, is aware, Your Lordship, that it's bordering Myanmar, Your Lordship. So, Your Lordship, it was brought to Myanmar, Your Lordship. It was brought to Myanmar with the intention to sell, Your Lordship. So, my humble and respectful submission, Your Lordship, considering the facts that at present, Your Lordship, there is easy access of drugs, Your Lordship, which is ruining thousands and hundreds of youths, Your Lordship. In my humble and respectful submission, Your Lordship, the contention of the accused that the accused is entitled to the full bail in view of the fact that the FSL report has not been filed with the charge sheet cannot be entertained, Your Lordship. Lordship, that is my submission, Your Lordship.
My Lord, just give a small rebuttal to what has been submitted. My Lord, as we stand here today, my Lord, my learned senior has submitted judgments of various high courts. My Lord, all judgments of various high courts do have persuasive value. But today, my Lord, as we stand, my Lord, there is a judgment of this Honorable High Court itself. Unless learned senior will place a judgment of the Supreme Court which says this judgment is per inquirum, then my Lord will not rely on this particular judgment. Now, the issue whether insufficient charge sheet will let a person go on default bail is still pending before the Supreme Court. Supreme Court has made it very clear that there is no embargo on any High Court or the trial court to grant default bail in such cases. Now, my Lord,
so the issue of per inquirum will come there.
Lordship.
As far as the previous order of this court is concerned,
Lordship.
Because at that point of time, these subsequent judgment or even the the comment rather, of the Supreme Court has not been clearly made known to this court.
Perhaps,
that's beside the point.
Perhaps, my Lord, that is correct, my Lord. But once again, my Lord, even those comments made in that particular proceeding does not stop this honourable court from exercising jurisdiction under 167(2).
Yes.
By what my learned senior has argued that I have filed an application under 439. The reason why an application under 439 was filed is because, my Lord, I was not supplied copies at that juncture. So without me going through the copies, I was not in a position to understand whether a supplementary charge sheet was prayed for or not. Had I knew the supplementary charge sheet was prayed for, even otherwise, my Lord, the only requirement on my part, my Lord, as far as there are so many judgments of the Supreme Court, Sanjay Dutt, Rakesh Kumar Pauls versus State of Assam, the only requirement on the part of the accused person is the willingness to furnish bailers to go on default bail. My Lord, I have argued this bail application on 3 grounds, my Lord, like I said yesterday. First of all, my Lord, I say that the charge sheet is incomplete, so I am entitled to default bail. Number 2, my Lord, on the merits of the case, my Lord, the only thing that they have been able to establish is that I am in touch with this person. Now, my Lord, they say I am in touch with this person for a few days. I have known this lady since childhood, my Lord. And both the people belong to the same community. Just because these people are in touch with each other will not establish conscious possession like what my learned senior has submitted. But he has placed case laws where, my Lord, the contraband has been...
What are the contents of this CDR?
Well, nothing. They've just what they have. It's not that calls have been recorded or the SMS have been recorded. It's just
can you peruse the case there? Lordship, the relevant part I have flagged maggot.
My Lord, my submission is that, my Lord, there is no merit in the case. My lord, you cannot say that I was in conscious possession of the drug because I was in constant touch with somebody. My lord. It's just nothing else. My lord, this will not even, this is not evidence at all, my lord. And lordship is very much aware, even if a statement is made by the co-accused, that cannot be used against me in the court of law during the trial.
That would be for
That's for the purpose
that
of
is for the
bail,
trial.
Your Lordship. The statement made under 161 is a relevant consideration, Your Lordship.
My lord, the reason why I'm making submission on merit is because, my lord, according to my learned senior, charge sheet has already been filed. And now even supplementary charge sheet has been filed. So I do have the right to make arguments on merit of the case.
Of course.
But whether the challan file has substance enough to ensure that I will be convicted on a later date. My lord, another aspect of my argument here is, my lord, I am a HIV positive patient, my lord. Now, my lord, the rigors of 37 will not apply. Lordship is very much aware of it because it is an intermediate quantity. So, my lord, my humble submission and my understanding is, my lord, bail, the restrictions to grant of bail is there under section 37 of the NTPS Act. However, bail is always granted under the Code of Criminal Procedure. Now, my lord, the provision for bail under criminal procedure very clearly states that in case of a woman or a person who suffers from sickness, my lord, even in non-bailable offences, 437, my lord, court can grant bail. And here, my lord, we are looking at an offence where the maximum punishment may be 10 years. My lord, there is no concrete, it's not that it should be less than 5 years or 2 years. My lord, the maximum punishment may be 10 years if I am convicted. So, my lord, at this juncture, my lord, I say that, my lord, case for bail is made out. My lord, sufficient sureties will be furnished. The undertaking will be given that, my lord, this person will not leave the jurisdiction of this honorable court. My lord, bail may be granted on strict conditions.
Another aspect I would like to highlight is regarding non-filing of the FSL report. Lordship will kindly refer to section 293 of the CRPC, Your Lordship. I missed that. If Lordship will kindly for the moment comes to section 293.
Yes.
Lordship is like this: report of certain government scientific expert. Any document purporting to be a report under the hands of the government of a government scientific expert to whom this section apply upon any matter or thing duly submitted to him for examination or analysis and report in the course of any proceeding under this code may be used as evidence in an inquiry, trial, or other proceeding under the code may, if it thinks fit, summon and examine any such expert as the subject matter of its report. So, Your Lordship, the trial court at any moment I can call that expert, Your Lordship.
See, that is for the purpose of evidence, recording of evidence. So it would not apply.
Well, if not on the aspect of default bail, my lord, otherwise also, my lord, my arguments may be taken into consideration, my lord. Of course, that is a very touchy issue, my lord, because of course this is a case where it's intermediate quantity, but in cases of commercial quantity, my lord, some people may take the benefit of such a situation. But otherwise, my lord, the other two aspects, which is on merits and the fact that, my lord, there are no rigors of 37 apply in this particular case, and this person is a woman suffering from a very serious disease. That may be taken into consideration.
Lordship, there is a medical certificate of 2021-22, Your Lordship. There is no...
HIV progresses, my lord. There is no cure till now. It's not that a medicine will cure my condition.
I'll have to go to this CD.
My lord.
So about the parties are passes orders.
Lordship. Highly obliged, Your Lordship.
Item number 4.
I think we'll have to continue in the second half.
Second half. My lord, actually the anxiety all these days was because the matter was fixed yesterday in the trial court. So, my lord, what the trial court did yesterday is fix the matter in the month of August. So, my lord, there is no such urgency as today. So, my lord, if a week after a week, in fact, my lord, I'll make a simple written submissions also, submit some case laws, and we'll argue the matter on the
Once the matter is out, you can do that.
My lord.
It's a very simple matter. My lord, this challenge only ground, my lord. This is a PC Act case, my lord. Sanction has been
only on the whether the registrar is authorized,
my lord.
or rather is the appointing authority.
Our case is very simple, my lord. I'll place some case laws. If sanction is
I'll
there,
also place some case laws.
if sanction is there, my lord, whether the sanction is valid or not will be determined in the trial, my lord. Only absence of sanction can be a ground for interference at this stage, my lord.
No, apart from that, there are other things also, my lord. I will place that judgment, my lord. You just let this matter come after a week.
On prayer made by the parties, this is matter after 1 week.
Maju.
Anything else?
Daily course list, item number 1.
Katuka. Order portion.
Lordship. Yeah, please, Your Lordship. I pray for 1 week time, Lordship, because the counsel for the appellant is currently available today due to personal difficulties, Lordship.
Oh, this is with regard to the condonation. You are for?
Appellant, Lordship.
On prayer made by the applicant, this is matter after 1 week.
How do you oblige, Lordship?
Item number 2.
Yes, who's appearing for? Has the rejoinder been filed? Have you received copy?
No, not yet.
None appears for the petitioner. On perusal of the record, it appears that the rejoinder to the affidavit in opposition filed by the respondent has not yet been filed. The petitioner is allowed some more time to file the said rejoinder. This is matter after 2 weeks.
Item number 3.
You have to file rejoinder?
I'm supposed to file a rejoinder, madam. And some more time.
On prayer made by the learned senior counsel appearing for the petitioner, the rejoinder to the affidavit in opposition filed by the respondents is allowed to be filed within the next date fix. List this matter after 2 weeks.
Item number 4.
May it please, Your Lordship. Your Lordship, in this matter, we have filed our affidavit of confirmation of service of notice. Your Lordship, let the matter come up after 4 weeks, Your Lordship, for hearing.
Then the counsel for the petitioner has submitted that the affidavit of service on the
All the respondents, Your Lordship.
notice deemed to have been served on all the respondents has been filed for this court. However, none has appeared on behalf of the respondents. One, is it respondent, all the respondents?
All the respondents, Your Lordship.
Mr. Karona has appeared.
No, Your Lordship, there was an issue, Your Lordship, while filing. We have clarified that during the last...
Okay.
Yes, Your Lordship.
Accordingly, since the respondents are not in attendance today, on prayer made by the petitioner, this is matter after 4 weeks.
Obliged, Your Lordship.
Item number 5.